Well, good evening, everyone. A very warm welcome to you all the people here in person and those online. I'm speaking from Gadigal country tonight and very pleased to be here. Pay my respects to the Gadigal people, the traditional owners of this country, and offer my respects to the traditional owners of all the country on which the court's registries are located. I also want to just specifically welcome a few special guests online. I want to welcome Chief Justice Ingram of the High Court of the Marshall Islands, Chief Justice Udit of the Supreme Court of the Republic of Nauru, and Chief Magistrate Pahulu of the Magistrates Court of Tonga, who are watching on live stream. And I understand we may have a number of other judicial colleagues from across the Pacific joining us remotely. All our Pacific judicial partners are very interested in the work the Federal Court's doing in relation to AI, and we are working with all of them on what is possible in their particular jurisdictions. The publication of the Court's AI practice note setting out our expectations and guidance about the use of generative AI marks a very important step for our court and for those who are appearing before it. In responding to the opportunities and risks posed by generative AI, as well as what really are becoming existential questions for the practice of law in our country and around the world, the Federal Court is focusing on reliance on a fundamental element of the administration of justice, which is competent and ethical practitioners who the judiciary can trust and who can be trusted by the public who engage with them. However, as an earlier event today in this very courtroom demonstrated, the Leading in Person Research Project collaboration with the University of New South Wales, we must also pay close attention to the growing cohort of litigants in person who are using our courts, and we must make sure that whatever we are doing in the space of generative AI is also reaching them. Accordingly, the practice note that we've put in place is underpinned by responsibility remaining with the human user. The person who signs a document, files it, relies on it, or presents it to a court remains accountable for its accuracy and its compliance with professional and legal obligations. Our practice note identifies circumstances where particular caution is required, including for privacy, and explains when court users must disclose the use of generative AI. The practice note is the product of extensive consultation, and I extend my gratitude to all those who've engaged with our court in that process. And in particular, I want to use this occasion to thank the judges of our court who've been involved in the AI project group for their work in developing the guidance, with particular gratitude to my colleague Justice Sharif, whose leadership on this project has been exceptional. As a contemporary national court, the Federal Court supports an approach to AI that is nationally consistent and involves partnership between courts, law societies, bar associations, research institutions, tech companies, and court users. We have to recognise that this is going to be an organic process. We must encourage collaboration between all the kinds of people that I've mentioned, and we must try as much as possible to maintain some consistency across all the jurisdictions in this country. Finally, while I note that the practice note and the issue of the practice note is a big step, it's not an end point. Technology, and we're going to hear a lot about this tonight, technology is evolving as we speak every day, and our understanding of its benefits and risks must try and keep pace. As the court will look forward to engaging with the profession and the community as we try and keep pace with these developments, and we will, as a court, try and remain proactive and responsive to change rather than resisting it. I extend my thanks to everyone who's speaking tonight, and I'm looking forward to hearing from you. Thank you.
Thank you, Chief Justice, and thank you all for attending both in person and virtually. Earlier this year, the court launched its practice note in relation to the use of generative artificial intelligence. As you've heard, the launch of that practice note was the culmination of a long period of consideration internally by judges of the court under the leadership of the Chief Justice. That process involved a long period of consultation with other courts and tribunals, the profession, the public, academics and universities, and the industry, including legal publishers and commercial providers of AI services. In particular, I would like to thank the legal profession led by the Law Council of Australia and each of its constituent bodies, including the various law societies and bar associations. All of the input we received was invaluable. You truly have been our eyes and ears and have helped guide us in the practice note that we have developed. As the Chief Justice mentioned, in the practice note, the court has endeavoured to balance the use of technology to assist litigants and to assist the profession in the efficient use of court resources and their own resources, but to balance those against time immemorial principles that guide the administration of justice in the Commonwealth. Whilst, as the Chief Justice has mentioned, the practice note is a finished product in one sense, it is unlikely to remain in that form as a finished product. We welcome all comments on the practice note, good and bad, and we can assure you that it's going to be under constant review as technology changes, further challenges emerge, and other challenges that have lain dormant come to the surface. The court sincerely hopes that all of you will continue to work with the court in managing these challenges. I would also like to thank certain people within the court. First, the Chief Justice is to be commended for her foresight, intelligence, and leadership on the issue. Second, I want to publicly acknowledge and thank the members of the AI project group, who included other judges and registrars of this court, who undertook a large amount of work that will always remain unseen. Third, I'd also like to acknowledge the staff of the court in all quarters who have been invaluable in their assistance and guidance, and in particular to Shani Doherty, who deserves special mention. We're about to move into a speech by the President of the Law Council of Australia, Tanya Wolff, and then into a panel session with Dr. Matthew Collins of King's Counsel and Professor Kimberly Wetherell. Before I formally introduce them, may I make some brief observations? Nothing, I would say, would add to the remarkable speech of Chief Justice Quinlan at the Minds Count annual lecture on 6 August 2026, which I commend to everyone. As will emerge from the discussion guided by Dr. Collins and Professor Wetherell, the use of generative AI is rightly to be viewed as a productivity tool, which is an aid of the practice of law and the administration of justice. We would lose something that is essentially part of civilization if generative AI was to become a substitute for the essence of legal practice and the administration of justice in courts, exercising the judicial power invested by Chapter 3 of the Commonwealth Constitution. Whilst in some jurisdictions, generative AI is being trialled and used in the determination of minor consumer disputes and alternative dispute resolution processes, it'll be important to draw the line somewhere. The administration of justice retains an essentially human dimension. The hearing and determination of federal legal controversies requires the exercise of human judgment, as flawed as that is. It is aided by humans, whether those humans are litigants, witnesses, solicitors, or barristers. What is involved is their evidence, their arguments, and ultimately persuasion to an outcome by assessing the evidence of humans and the use of human logic based on a set of principles and laws determined by humans with all its attendant complexities. Where the lines get drawn will undoubtedly be negotiated in the coming years and decades. Judges, of course, have a vested interest in where the line gets drawn, but ultimately those questions will need to be determined and answered by those who judge the judges, which is all of us. All of us will need to remain vigilant as to what we desire from a civilised and good society. That'll include the types of matters that will be touched upon by Professor Wetherell as to the education of the present and future generations of lawyers. All of us have a vested interest in the future of the legal profession. Can I just briefly introduce our speakers? Tanya Wolff is the President of the Law Council of Australia. She's a former President of the Law Institute of Victoria. She's a Legal Director of First Step Legal, which is a community legal centre that has its objects of fostering health justice partnerships. She's also a member of VCAT and of the Mental Health Tribunal in Victoria. Dr. Collins needs little introduction in this court, and probably to most of you. His CV indicates that he would easily outcompete any large language model for the depth of data that resides in his mind. He's a former president of the Australian Bar Association. He's a senior fellow of the Melbourne Law School. He's an eminent legal practitioner, not just in defamation law, but too many others to mention. He is also a responsible user of AI, and I stress the word responsible, as we will shortly see. Professor Weatherall also needs little introduction. She's a Professor of Law at the University of Sydney. She's a world-renowned academic and intellectual property, but for many years and too many to mention. She's been prophesying about the new dawn that has arrived. She's a Chief Investigator with the ARC Centre of Excellence for Automated Decision-Making and Society. She's a co-director of the University of Sydney Centre for AI, Trust and Governance. She's a fellow at the Gradient Institute, a research institute developing ethical AI, and was in 2004 a member of the Commonwealth Government's temporary AI expert group. I'll welcome Tanya now to make her presentation. We should have time at the end of Dr. Collins and Professor Weatherall's presentation for questions, which will be followed by refreshments.
Thank you. Good evening. I would like to echo the acknowledgement given by the Chief Justice of the traditional custodians of the lands on which we meet, the Gadigal people of the Eora Nation, and I to extend my respect to elders and to any First Nations people who might be here today. I'd like to thank the Honourable Chief Justice Mortimer and the Honourable Justice Sharif, Chair of the Federal Court's AI Project Group, for bringing us together today, and acknowledge all judicial officers and dignitaries and colleagues here. The results of the survey into the use of artificial intelligence by the legal profession, released by LexisNexis this year, tells us that more than 2/3 of us are using or planning to use generative AI tools in our work. So the genie is out of the bottle, and we cannot and should not wish to put it back in. Just yesterday, in the Supreme Court here in New South Wales in Sydney, Sir Geoffrey Voss, England and Wales Master of the Rolls, told the profession that it has no choice but to wholeheartedly embrace and adopt AI, and that a justice system which fails to move with the times risks making itself irrelevant. I don't disagree. The profession does not have the luxury of standing still. AI offers our profession and the justice system more broadly significant opportunities, but embracing a technology wholeheartedly is not the same as embracing it uncritically. Opportunity and risk sit side by side. I don't need to detail those risks to you. I'm confident that everyone here in this room is aware of them, if not seeing them already in practice. From false citations to errors in automated decision-making through to hallucinations in AI transcripts which people rely upon as being a source of truth. And then there is the self-represented litigant who is assured by AI of having a surefire winning legal argument and encouraged to keep fighting and appealing, even in the face of unsuccessful judgments. One of our own courts recently described this as the sycophantic tendency of large language models to prioritise user approval over truth. That places real demands on our justice system. That same LexisNexis survey found that users of AI in the legal profession have concerns around accuracy, confidentiality, and bias, and are looking for guidance to support those responsible and to support the responsible application of those tools. We need robust guardrails, and we don't want to unnecessarily impede innovation. The Law Council has generally supported an overarching principles-based response to AI, one that can accommodate technological change and remain workable as AI tools and professional practices develop. We all have a role to play in shaping how AI can be safely and effectively used to improve the administration of justice rather than hinder it. The Law Council commends the leadership the Federal Court has shown in developing this practice note. We appreciate very much the Court's broad consultation and careful consideration given throughout the process, including the invitation here today to share early feedback from the profession on its operation. Guidance that supports responsible use of AI, as demonstrated by the Federal Court's practice note, is preferable to a general prohibition that may quickly become impractical or outdated. The central message of the practice note is that using Gen AI does not alter a practitioner's existing duties to the court, the client, or the administration of justice. And this is a fundamental principle that we as a profession must never disregard, regardless of technological advancements. AI can help us in our work, but it does not remove or even reduce our professional and ethical obligations, nor can it be relied upon as a substitute for legal knowledge, experience, or expertise. AI can make lawyers more effective, but because it does not owe a duty to the court and has no professional indemnity or accountability and no ethical obligations, it cannot, at least for now, replace a lawyer or a judge, I hasten to add. Practitioners remain responsible for the work produced in their name, satisfied that the facts relied upon can be proven, cited authorities are real and support the propositions that are advanced, and that evidence is reasonably likely to be admissible. They, in other words, must be able to show their work. If I can point your honours to one area where the profession's views remain genuinely unsettled, it's the question of disclosure. Specific issue I understand that I've been asked to address today. There are varying views across the profession as to how much and in what manner should they be required to disclose their use of AI. Some of the Law Council's constituent bodies considered that increased disclosure obligations on court users promote transparency and accountability. Others consider that as AI becomes embedded in commonly used software, disclosure requirements may become overly burdensome, difficult to identify, and will be of limited practical value. We've also heard concerns that detailed disclosure obligations may risk revealing aspects of a party's forensic strategy. The practice note requires users to be able to tell the court what Gen AI was used, how it was used, and for what purpose. In practical terms, practitioners may need to keep sufficient records to provide that explanation. This avoids imposing automatic disclosure for every use of Gen AI, while ensuring that users can account for their use when disclosure is required under the practice note or directed by the court. In a limited number of circumstances, the practice note mandates disclosure of the use of AI, for example, where it is used to summarise information upon which a witness relies to make a statement of fact or to express an opinion. It's worth noting that Australian courts have not yet converged on a single answer to the issue of disclosure and permitted use of AI. The preparation of expert reports is a good example. From the Victorian approach of emphasising that particular caution must be exercised where AI is used by experts, to the requirement in New South Wales that experts obtain the court's leave before using generative AI in preparing a report at all. The Law Council does not seek to adjudicate between those approaches. Each reflects a considered judgment by the relevant court. What we would say as a general rule of thumb is that we favour national consistency wherever it's practically achievable, precisely so that court users moving between jurisdictions are not left navigating materially different disclosure regimes for what is, in substance, the same underlying risk. We also welcome the court's expectation that anyone using Gen AI must ensure it does not compromise accuracy or professional standards. The presentation of false or inaccurate information to the court is unacceptable, whether it's generated by a person or an AI system. The misuse of AI and headlines reporting hallucinated cases in pleadings only serves to undermine the integrity of the court and trust in our institutions. We're pleased that the practice note references the risks to privilege and confidentiality of using Gen AI, cautioning against the input of sensitive information into Gen AI platforms where data handling and storage practices may be unclear. While we recognise that individual courts may legitimately adopt different approaches on the use of AI, we're also conscious of the proliferation of guidance materials, and varying approaches can result in unhelpful contradictions and confusions. While the profession is used to dealing with different rules for different courts, we do need to pursue a greater degree of national consistency wherever it is practical to do so. That is a message that our constituent bodies have asked us to respectfully relay to the judiciary on their behalf. Regular review of the practice note will be important. The technology and the ways in which it's used is changing rapidly. Continued consultation with the profession and other court users will help to ensure that both the practice note and the supporting resources remain workable and current. Thank you again for your careful consideration of the profession's views as the justice system moves forward. New technology may change the tools in our hands, but it cannot change the hand that must hold them. That work of judgment, of care, of accountability remains ours, and I trust it will remain so for some time to come. Thank you.
Well, thank you very much for the invitation to speak today. And could I join with the President of the Law Council in thanking the Chief Justice, Justice Sharif, and the judges of this court for the leadership that has been shown with the introduction of the practice note. I mean, to my observation, for what it's worth, it has been broadly welcomed in the profession as striking the right balance, at least in the second half of 2026, between, on the one hand, embracing the technology and, on the other hand, reminding court users from counsel to self-represented litigants and parties of their time-honoured obligations. Also join with the President of the Law Council in saying that it will be important for this to remain an iterative process. I think we've all seen over the last 6 months more progress in AI than we had seen in perhaps the years since the introduction of ChatGPT 3.5. The progress is nothing short of staggering. I've come to the view, I think over the last 12 months, and I know Kimberly shares it with me, that the disruptive power of AI is such that it is transforming and will continue to transform quite fundamentally the way in which law is practiced and justice is delivered. It's already reshaping legal practice in ways that is reminiscent of the arrival of email and the internet. We're going to begin today with some brief remarks about what's happening in the profession and the academy. I will tell you about the work that the Victorian Bar in particular has been doing, its approach and the strategy it has adopted to seek to equip barristers with the knowledge, tools and training that are necessary for AI to be used productively, responsibly and in accordance with ethical obligations. Kimberly will address us on how AI is affecting legal education, what a conundrum, and give us the benefit of her global, really unparalleled global perspective on what's happening overseas, including in courts overseas. And for anyone who remains sceptical, we are going to take our hearts in our throats and attempt a live demonstration of the ways in which AI is already being used by practitioners appearing in this court, consistent with the practice note which has been introduced. We'll use some worked examples from real cases and we will try our hands at a live demonstration that will unfold in the screen before you. If it defames anybody, I shall seek to diffuse that through the quick introduction of a defence of qualified privilege. There's a spectrum I think obviously enough between those who believe that AI will prove to be just another tool, a bit like email or the internet. And at the other end of the spectrum, there are those who think that the justice system is existentially threatened by it. We're realists, Kimberly and I think we're not one-eyed advocates of AI. It is in its current state, and I think some of the demonstrations we do today will demonstrate this. It is flawed, sometimes deeply flawed, sometimes dangerous. But it's also, I think, the most remarkable technological development we've seen in our lifetimes. And it would be foolish to think that it doesn't pose very serious challenges for the functioning of and respect for institutions and the rule of law. Now, in Victoria, our Bar Council established a steering committee, which I chair. The members of the committee are drawn from different practice areas with different levels of seniority and with a view to reflecting the diversity of the modern bar. Our remit is to bring together all of the strands of thinking about AI as it affects the role of the advocate, from the technology itself to confidentiality and privilege concerns, ethical obligations, compliance with court requirements and client requirements, and ongoing training and member engagement. It's a big remit and it needs to unfold very quickly. We started with an environmental scan, what we called an environmental scan. We wanted to understand what was happening in the legal profession at a point in time, that point in time being earlier this year. Now, the data on this slide comes from work that was done by the Centre for Artificial Intelligence and Digital Ethics at the University of Melbourne and the Law Institute of Victoria, but it's also informed and supplemented by work that was done by the committee I chair. We drew two broad lessons from our survey of what was happening in the legal market in 2026. The first is that of those law firms that have adopted AI tools, a handful of major players have emerged. Harvey and Legora, legal tech AI platforms, are the two that have emerged as having the highest degree of market penetration in the Australian market. Curiously, it seems that Australian firms are adopting off-the-shelf products like those adapted to their environments more so than our counterparts in the legal professions in some other countries, notably the United States, where there's a preference in big law for bespoke products. As you can see from the scan which we adopted, Harvey and Legora are significantly out in front. The traditional research publishers, LexisNexis, Thomson Reuters, have their products, Lexis Plus AI and Westlaw Co-Counsel, which have a significant degree of penetration in the market. They, of course, are historically research products used for legal research, but they now have AI add-ons and they've got a significant degree of market penetration and their products are rapidly becoming more sophisticated. Microsoft Copilot is a general AI tool which is provided now as an adjunct of enterprise-grade versions of the Microsoft suite of applications like Word, Excel, and Outlook, which are used by many, many law firms. So while not legally, they're not legal harnesses providing specialised legal AI services, their integration with those products means that they are being widely used throughout the profession. There is then a suite of more bespoke and smaller and specialised legal AI tools. And Cicero emerged in our review as a product that has found favour in some parts of the legal profession, but there are many, many more. The second lesson we drew is that big law firms seem to have already deeply embedded AI platforms into their work streams in ways that has put them ahead of the rest of the legal profession, the bar and courts, tribunals and government departments. It's already having an impact on recruitment of graduate lawyers. Smaller and mid-sized firms, our review found, are a bit of a mixed bag. Some have enthusiastically adopted AI, but many others are at much earlier stages, as are government departments and, generally speaking, courts and tribunals. Some state court systems are yet to approve even a single AI product for use by judicial officers and staff. And the third lesson we drew from our scan was that the bar is vulnerable. Some law firms have told us that they are using AI tools already to do much of the work that was traditionally the province, particularly of the junior bar. And at the same time, the most powerful AI tools, the ones that are being used by major law firms and corporates, have been beyond the reach of barristers because they require enterprise-level protections that are not available on individual subscriptions, and they require sophisticated IT support. Now, that's led many barristers either not to engage with AI at all, which is surely folly in 2026, or to use consumer-grade products like ChatGPT and Claude, which is risky because even in their paid versions, they carry no contractual guarantees in relation to matters such as the data on which they're trained, or cybersecurity, or confidentiality, or privacy. Our solution is to look at putting together a portfolio of enterprise-grade AI platforms that could be made available to barristers. Obviously, my focus is on Victoria, but via a central contracting entity in much the way as would occur in a law firm environment or in a corporate, and to promote the availability of other platforms that can be subscribed to on an individual basis, which we are satisfied offer an appropriate level of protection. We see that approach as being appropriate to the exigencies of practice at the bar. It's consistent with the independence of the bar. It's consistent with differing appetites of individual barristers in relation to the use of AI. It's consistent with differing budgets from entry-level solutions to the most sophisticated products currently available. Now, this slide is not exhaustive by any means, but it shows that some of the major products we've been trialling at our bar include the ones that you see in the table: Harvey, Legora, Claude Enterprise and Copilot, and then a large suite of other products which appear in smaller print at the bottom of the table, which are available on an individual subscription basis. Our aim is not to direct barristers about how they ought to use AI, but rather to provide them with the basis for making an informed decision about what product might best fit their particular appetite and practice. We've also developed a risk framework to assist barristers in the use of AI. This is just a simplified version of it. We see risks as falling into three broad buckets. First, there are non-negotiable limits about whether AI can be used at all. Does an applicable court rule or practice note prevent or limit the use of AI? Is there a disclosure obligation to the court or to the client or to others that means the product can't be used or has to be disclosed? Has the client imposed limitations on the use of AI generally or in the specific matter? Or are there limitations in relation to the jurisdiction in which data can be stored or processed that affect the ability to use particular AI platforms? We call those non-negotiable limits. Next, there are the risks to be considered before actually using AI. Is the proposed tool enterprise grade or consumer grade? Our advice to our members is that confidential information should never enter a consumer grade tool. If confidential information is to be processed, are the terms of the enterprise grade tool adequate in relation to questions such as training and data security, cybersecurity, privacy, and data residency? Is the tool adapted to the particular matter and use case? Some tools are completely inappropriate for use in legal research. Others are weak on matters such as document management and analysis. Has the proposed use of AI been disclosed to instructors and covered in cost disclosure agreements? And we've drafted sample cost disclosure clauses in relation to the use of AI for barristers to consider when giving their disclosures to their clients. And then finally, our third bucket of risks concerns the actual use of AI in legal practice. And we encourage our members to think about what is the risk profile of the proposed use case. Some are high reward, low risk, others are the reverse. Are there safeguards in place to catch hallucinations, and has every output been verified? But actually, we see the last of these buckets, which attracts a lot of attention, a lot of media attention, and those poor members of council who have been caught with hallucinated citations in submissions know this. But this is not our greatest concern because our obligations fundamentally haven't changed. If you're not detecting a hallucination or you're missing an error which has been made by an AI platform, then you're very unlikely to have acted in accordance with your professional obligations, just as surely as if you'd missed an error that was made by a paralegal or a junior. And then now, finally, what has become this very long introduction, can I close by making these observations? AI is here. It's why we called our presentation, Kimberly and I, present tense. Last year we might have called it, it's coming, prepare yourself, or future tense, but it's here. And it's being used by legal practitioners today in increasingly sophisticated ways, including members of council. And while there is understandably a focus on misuse, AI undoubtedly is able to be used in ways that improve productivity and the quality of legal work without compromising professional and ethical obligations. The art is in recognising that line. And dare I say this, Chief Justice, as the court continues its work on the adoption of AI, a process such as that which we've adopted, we would commend. It is important, we would respectfully suggest, to understand how the profession is using this technology and how that's changing over time. It is important to engage with and test a range of platforms, cautiously moving towards adoption of those which pass rigorous standards and which have been developed with an eye to the protection of obligations. And then there's an obligation to continue for continuous training and monitoring on the responsible and ethical use of the tools.
Great, thanks, Matt. And thank you to the Chief Justice and the court for inviting me along to be part of this event. This is such an interesting / controversial / challenging area to be thinking about. I wanted to give you a bit of a perspective from legal education and from the Sydney Law School where I work, because education does seem to be one of those areas which has generated perhaps some of the greatest attention, perhaps panic around the impact of the use of AI. It sometimes feels like people assume that those of us who are entrusted to educate the emerging generations of lawyers, well, we get one of two responses. Either we should be seeking to banish AI entirely from the hallowed academic halls in which we work, or at least the exams, or we should be instead adopting it wholeheartedly, devoting ourselves to teaching our students the best way to use it. Like the bar or the courts, people like me and people in legal education are doing actually what we've always done, right? Same as you, we are applying the same principles of what we've always been trying to achieve and just working out how to do it with the new tools and in the new environment. So we are seeking to equip our students for life in the legal profession. We're still trying to train them to think very deeply about the law, about doctrine, about legal principle, about law's history, its quirks, how to use the tools of the law and other tools to solve legal problems and further justice, rights, the rule of law, all those things that we hold dear. The environment, the technologies change, but the basic principles that govern us don't and haven't. I can assure you that we are very conscious of the various governing considerations that the legal profession rightly imposes and expects us to comply with. You know, we are so governed. We are governed by federal requirements, by university requirements. We are, of course, deeply engaged with the processes of reform being considered by the Legal Admissions Consultative Committee. And of course, the Council of Law Deans quite some time ago provided definitive threshold learning outcomes. These are the minimum levels of competence that we are expected to provide our graduates with so that they can be admitted to practice in the profession. And those haven't changed. So we are still trying to make sure that we equip all our graduates with the knowledge and the skills that that they will need to succeed. It is, of course, our responsibility to think about what that means in today's environment. In terms of skills and knowledge, because of course this is one of those areas where people get very worked up, right? And we're going to lose our skills because we're going to all just use the AI to do all the analysis for us. The terms that are being bandied about in academia at the moment in this space are cognitive surrender, surrendering your cognitive processes over to the machine, cognitive offloading. It's too hard, I don't want to think about, let Claude do it for me. Obviously, we can't let our students do that. It is still our fundamental responsibility to teach both legal knowledge, but also understanding, the ability to critically analyse and apply the law, and other professional skills, including clear communication, writing. Believe it or not, they still do need to learn to write because some of the stuff that Claude produces is just painful. And, you know, professional responsibility. So, and look, all of this is super important because in news that may well be comforting to many of the people in this room who have hair equally as grey as mine, or in a kind of senior revenge kind of way, that the emerging research across a range of professions indicates that the people who benefit most or get the greatest augmentation from AI technologies are in fact those with deep domain expertise, because they know how to drive it, they know how to instruct it, they know what they're looking for. But not just that. It's not just that we're better at spotting errors because we know stuff. It's actually that the versatility and range of human intelligence and wisdom that we get from experience means we see how the parts fit together. And that really matters when you are getting the sort of surface level predictions of knowledge. It is because we make connections or leaps that the very latest research on the very latest model suggests that the AI can't do. There are leaps it can't make. The AI scientist is not yet with us in that true sense of what a scientist is, of, you know, true discovery. So what that means for us is that we still have to be finding ways to teach those fundamental skills, because that is the only way that that our students will benefit from this technology and make the best use of it. So we have at Sydney Uni, since this hit us like a ton of bricks in 2022 and then early 2023, we have been undertaking a quite extensive exercise in curriculum redesign, which sounds about as exciting as you'd think. But actually, what it has prompted us to do is really look at how we are in fact teaching skills across the curriculum. You know, we always assumed that, you know, by getting people to write essays and by having them attend class and listen to us talk about the law, that they would learn critical thinking and engagement. And I think most of us know that that probably wasn't always true, at least of the lectures. But we are much more consciously trying to scaffold those skills through the degree, where we've actually talked to our colleagues to work out what they're teaching, which is great, because it means that we're able to build. So there's been quite a strong focus on working out how we can be teaching and testing the skills that are so important. Actually, it's been kind of wonderful because we are now actively engaging with our students in their thinking and learning in a way that perhaps we just assumed happened before. There's also, this is the other big panic, right? Assessment. I hear plenty of panic about how traditional assessments can no longer possibly work and we should all go back to doing handwritten exams in freezing halls. No, thank you. Actually, at Sydney University, what we have is what we call a two-lane model. It's really just a fancy way of saying some of our assessments are secure and AI can't interfere, and you can ban AI and you can monitor that. That does include exams in freezing halls, but it also includes other things like presentations, oral defence, oral dialogue, having conversations with people about the research and the work that they've done. And let me assure you that that is much more enjoyable than marking essays, and I love it. We are now having effectively oral dialogue with our students about the work that they are doing. That's so we have lane 1, which is these secure assessments, and then we have lane 2, which are the unsupervised tasks, the things that people do in their own time at home. We are not able to ban the use of AI in those assessments. We started out actually letting people just make their own decisions because you can't enforce it. And because it destroys trust amongst the student cohort. Because of course, if you do try to prohibit the use of AI in an unsupervised assessment, everyone thinks that someone else is probably using it. And that's not good for anyone. So our job in that context is to ensure that students are guided on better uses. So we are teaching those skills, and we've given them access at Sydney University. We've just recently given all of our students access to Harvey AI as well as other tools. They've had Microsoft Copilot for a while, and we've now extended a bit. So even in the areas where you would have thought it was most difficult to guarantee that we were still teaching the skills, we are putting together assessment regimes and courses that acknowledge people are working with AI, but also work with them to test their engagement with the technology, but also their own arguments and their understanding. So we are required to ensure that they get legal research skills and the ability to evaluate and synthesize factual, legal and policy issues, as we should. And we are designing and working to design assessment regimes that try to ensure that people are still doing research and still going away and doing research, but we're scaffolding it with all kinds of oral engagement, oral defense, and other exercises to make sure that we are also testing people live and testing and, explaining what good use looks like. And for what it's worth too, we have engaged with our students. We've surveyed, of course, like everyone does these days, and they show the same. What they're telling us is that they are making use of AI, but that use is bounded. They're using it in summarising, in proofreading. Very few of them told us that they were using it in drafting. But, there's a significant minority who use it rarely or never as a quite principled or deliberate choice. But they are also telling us that they believe that thinking like a lawyer, learning to think like a lawyer is not something you can cognitively offload or cognitively surrender. These are very intelligent young people. They're actually the ones who are subjected to the most AI slop too, if you think about it. So they're very aware of the limitations and they're very aware of the effects. And by having this sort of two-lane process, I hope we are responding. It's also worth noting, forgive me, international research suggests that students in law and the humanities are at the lower end of AI usage. Again, probably because they're aware of the way that words and writing is thinking in a way perhaps that other students may not be. So in short, our internal evidence is a student cohort who are experimenting cautiously, sharing many of your concerns about both accuracy and the impacts on thinking. Another thing to say, and we are learning by doing, right? We are constantly keeping these processes under review. We are constantly talking to our students and our colleagues about what works and what doesn't. Another thing about the need to be thinking about training the next generation of lawyers is, as Justice Sharif mentioned in his introduction, this is not just an us thing. This is a you thing too. It's a members of the profession thing. You here today know even better than me that while the kind of training for the profession that I do is important, training in the profession matters just as much. Right? And in how to be a lawyer and a lawyer with integrity and skills and deep understanding of the law. So the question for the profession is how we nurture the talent that we build, you recruit, and you take forward. Are you finding the same things that we are? That some knowledge has to be tested and developed through direct engagement and dialogue? Are you doing the kind of mentoring and oral defense with your juniors that we are finding that we need to do? I'd love to have a discussion about some of that, because one of the things that I talk to a lot of researchers across the university who go and talk to people in various professions, and they say that some of those senior junior conversations have to be actively built in these days when it's just easier to ask the AI instead of your junior colleague to do a quick job. So thinking about how we're actively doing that is really important. The other thing I kind of boldly suggested was I might talk about use of AI in the courts, which can only be said to be foolish when you're speaking the night after the John Lehane Memorial Lecture by the Master of the Rolls and the night before the Francis Gurry Lecture by Chancellor Colin Burse. It would be bold, perhaps foolish, to try and say too much. But I do want to say just a few things. One focuses in on the practice note, which is actually I had a research assistant, a real human one, actually go and read a bunch of practice notes. And there's a lot of consistency in the messaging that we're getting from a lot of these notes. I did want to say that one of the things I love most about it is point one, it starts with knowledge. You are expected to understand or know the limitations of the technology. I can't emphasize enough how important it is that we all learn more about not just its limitations, not just that it hallucinates, but kind of why. You know, like how does this technology, broadly speaking, how does this technology work? And why are some of the limitations going to continue into the foreseeable future? Learning how the technology works, and I do this because I work with technologists, I actually build AI agents to do policy simulation. Now, there's a phrase you didn't expect to hear from a law professor. We're building AI agents to simulate people for policy purposes. It's fun. It's really fun. One thing you learn about through that process is how hard it is to do well, how hard it genuinely is to get these things to act like humans. It's really, really difficult. But another thing that's been great about that is it's really empowering to learn why the technology doesn't always work. It kind of removes some of the magic, which, you know, in the law is a good thing. We tried to remove the magic from the law quite a long time ago. Not the intellectual magic, but, you know, the woo-woo magic, the sort of witches and stuff like that. Another thing that strikes me looking at the practice note is how interesting it is to consider how similar your journey is to ours. We started by trying to ban the technologies, we moved to principles, we are engaged in a process of cautious but semi-enthusiastic engagement and experimentation, and we are still working out how to do disclosure from our how to ask our students to disclose or not disclose their AI use. I'm not a massive believer in the attempt to get detailed disclosure, and that's actually one of the reasons why Lane 2 and assuming that it's used but then guiding it is, in my view, a better approach. And the third point I just wanted to very quickly highlight is that last point there, which is the Nuffield report, which highlights really critical evidence gaps in our use of AI. So the Nuffield report was looking at AI use in the UK courts. And what it highlighted was, while there was quite a, limited evidence of the use of systems and their evaluation, a lot of that evaluation gave no evidence on how this was being received by or experienced by members of the public and its potential impacts on how people perceive the feeling of justice. Is justice being delivered? Is justice not being delivered? It's one of the reasons why I'm kind of thrilled that you're working with UNSW, even if you are working with UNSW. Kidding. Love UNSW, great colleagues there, great project. No, seriously, I'm delighted that you are doing that work because that is exactly the kind of evidence we need. We need to be talking to litigants about how this is experienced. I have done some interesting experiments with a guy called Joe Tomlinson over in the UK where we sort of give people scenarios, one using AI and one described as not using AI, and see how people respond to really try and isolate the impact of using AI on how people perceive processes. And the research, which is also cited in the Nuffield report, suggests that actually saying that AI was used in a decision can reduce confidence and the perception that justice is being delivered. And so these are the things we need to be thinking about. And I could go on, but I don't want to take up too much time because I'm sure you'd all rather watch Matthew Collins bravely try to do a live demonstration of AI use. So let's move to the case studies and the examples, but really looking forward to further discussion with all of you.
Just before we move to that, I've shared with Kimberly that I've been doing a controlled experiment for 8 months now on the use of AI in the context of teaching law. And late last year, I conducted a slightly unethical experiment, I've come clean about it since, which involved getting ChatGPT to design a simulated student to sit a master's level exam in a subject that I co-taught at the Melbourne Law School. Unbeknownst to my colleague, I put the result, a fake student number, on the exam and slipped it into the marking. And we then compared, we both marked the paper and compared the results. This was in December of last year. The product was a Claude product. Opus 4.5 was the frontier model at the time. We agreed that the output merited an H2B, 70%. The average student result was 74%. And we thought that was pretty remarkable because Claude hadn't been to even 1 minute of the 25 hours of lectures that we had delivered. The course materials were the usual sort of mess that you give students, you know, and a photocopy of a case here and a section from legislation there. And so Claude didn't know the hot topics that were focused on in class. I didn't change a single word of the output, but I did have to reformat it to get the footnotes to look right and so on. I came away a bit smug, Kimberly, because I thought, okay, I can teach it. I know what the answer is. That just means an H2B is now the pass rate, and we're looking to see, have the students learnt what it takes to convert an H2B to an H1? I've redone the experiment 3 times in the last 3 weeks using the latest frontier models. On each occasion, it has returned an H1 result, unquestionably an H1 result, in a beautifully formatted document where the footnotes are perfect, the citations are in accordance with the Australian Guide to Legal Citation, and there are no discernible hallucinations. This is the conundrum that teachers face. Let's have some fun though with the use cases. We're going to try our hand at 4. We might not get through all of them. Editing, polishing, and verifying submissions are really no-brainer use case for practitioners and judicial officers. A much more complicated one involving the analysis of transcript, which will be our first one. I'll just get that underway in a minute. The use of AI to do the tedious job of identifying potential objections to the admissibility of evidence, and then the use of AI to assist in preparing cross-examination. But let's begin with the live demonstration. Could we flip over to the other screen? Thank you. Now, I'm going to start here because it's likely to take a few minutes. It can work in the background while we do some other demonstrations. I'm going to use a case in this court, which occurred in this court, which everyone is likely familiar with, and where all of the relevant information is in the public domain, so we're at minimal risk in doing so, in exposing it. It's the defamation proceeding brought by Bruce Lerriman against Network 10 and Lisa Wilkinson. The trial ran for 23 sitting days in late 2023. When the respondents closed their case, almost on Christmas Eve, the transcript ran to 2,205 pages. In this example, I've loaded the transcript into a product. In this case, the product is Lagora's AI product, all 2,205 pages. And I've loaded my personal writing style guide into AI, and I'll explain what that is in a moment. And now I'm going to give it a prompt, hopefully. So I'm asking the AI, please review the transcript in this trial in which I'm acting for the first respondent. I'm getting my thoughts. You notice I said please? We all say please to AI. For when they become our overlords, we hope they'll look kindly on us. Yeah.
Actually, the research suggests it works better when you do that.
Yes, right. I'm getting my thoughts together for the closing oral and written submissions. An important point in the case concerns the credit of the 2 key protagonists. You'll notice I don't name them. My ultimate submission will be that while both had seriously impaired credit in relation to the key issue in the case and alleged sexual assault, the complainant's evidence is credible and should be accepted. About 3 weeks before the alleged assault, on the 2nd of March 2019, a disputed event occurred. Please review the transcript, identify all witnesses who gave evidence about that event, identify the key integers of their evidence, identify the consistencies and inconsistencies, and collate it into a table, and then set out what, if anything, can responsibly be said about their credit. Do not do any research in relation to the matter other than that derived from the transcript itself. And so let's press go, and we'll move on to another. How do I do that? And so you see that's just really in plain English. And it goes away, and it will probably take 10 or 15 minutes. So we'll come back to it. It analyses the query, and you see the thought process as if you're looking inside a mind. So first of all, it says searching documents for the Kingston Hotel 2nd of March in the transcript. Found 2 results in the transcript. No doubt there's more than that. It continues reading, analysing, coming up with a plan for responding to my query, thinking about the structure, thinking about the way in which I want it presented. We go back to the PowerPoint for the time being. We'll come back to this. Now, I mentioned the style guide. This example is one I think every judicial officer and legal practitioner should embrace. I gave AI 8 examples of submissions that I had signed off on in recent matters, ones that I thought were representative of my own idiosyncrasies. I uploaded them, and I asked the platform to develop a style guide which could then be superimposed on documents in future, including, for example, drafts provided to me by my juniors or rough drafts that I had worked on that I wanted to have tidied up. The platform went away, and about 10 minutes later it came back with, and I'm not kidding, a 21-page style guide that my psychiatrist would find very helpful. It covered everything from my preferences in relation to headings and paragraph numbers, to spacing, fonts, citations, abbreviations, pinpoint references, what hyphens I like used in transcript footnotes, the use of end dashes, the Oxford comma, ordinal arguments, signposts, capitalisation, and all sorts of other gems. In relation to content, it said that and I quote, deploy short evaluative sentences sparingly that land with force precisely because they are rationed.
Is that only the good bit that you're reading out?
Said that where a point cannot sensibly resisted, my temptation is to, quote, concede it in one sentence and pivot back to the primary submission. Pretty good advocacy. Said the first sentence of a rebuttal paragraph should state the correct position, not the opponent's error. It said, do not open a sentence with, it is submitted that, in this regard, as mentioned above, or any comparable forms of filler. Well, let's see what happens when it's actually applied. So there's some of those things I've just read out. Here, I gave it a submission, which I manually tampered with. So I put in some deliberate typos. I changed some of the case citations so that they were false. I moved some to different courts. I changed judicial officers' names. I changed some of the pinpoints so that they were inaccurate. And I left some placeholders for, I need to go back and find which paragraph in the judgment that proposition came from, and so on. Then I said to it that it should read the draft submission, apply my style guide meticulously to it, and check the references and return it to me. Now, when it's done live, it comes back in a document with clickable reference points so that I can go to every change which has been made and see the basis for it. And it produces it in markup form in a Word document. But just for illustration purposes here, you can see the original draft had an error. It said by his application under section 36 of the Federal Court Rules. And the AI picked up not only that it was not a section but a rule, but it also picked up from my style guide that I prefer the abbreviation R without a full stop when it comes to a reference to rules. It then picked up 2 obvious typos in the first paragraph. It dispensed with throat clearing in the next paragraph. So instead of saying with respect in considering an application for a stay, it just became in considering an application for a stay, which is very, very much what it was directed to do. And then it'll just scroll through a few more. It struck out editorialising, got rid of, Justice Gordon would be proud at the number of adjectives that were deleted from this document. But then sort of more interestingly was the way in which it was able, with a proper prompt, some called excising an aside to the bench, and a good edit, by the way. That submission is, as the court knows, incorrect, is a presumptuous submission. The submission is incorrect is better advocacy. But then when it came to citations, it corrected them it asked me, first of all, if it could go to the Federal Court website to look at its repository of judgments. It needed to look at some Victorian judgments, so it asked me whether it could go and see those. And it picked up things like correcting titles, correcting citation names, correcting pinpoint references that I deliberately changed to make wrong, picking up that one judgment had been in the citation, the draft citation headed in the Victorian Supreme Court. It picked up that it was in fact in the Federal Court and corrected the identity of the judicial officer. On the ones that we can now see on the screen, we can see it picking up pinpoint errors from references in the judgment and picking up one of my placeholder XXX in highlighted text, went back to the applicant's submissions and found the paragraph that was authority for the proposition that was cited in the submission. And because it had an audit trail of clickable hyperlinks, I could go through it and tick them off one by one to check that they were accurate. Finally, it picked up from the style guide that I don't like pre-nominals or post-nominals in the signature block. Now, this to me is a simple, sort of everyday use case, but a very powerful one. I now can provide that style guide to my juniors to help them produce better quality drafts before they come to me. If I've got a rough draft, I can run it through the style guide to produce a more polished draft. If I receive a draft from someone to settle, I can just ask the tool to run my style guide over it, which saves me from tearing my hair out about Oxford commas, ordinal argument signposts, and so on. I mean, how's our live demonstration going?
It's done.
Oh, can we go back to the live demonstration? So you can see here, that was what, probably 5 minutes, maybe a bit less. And what the platform has returned is this. I've reviewed the transcript for all the evidence concerning the 2nd of March event. 4 witnesses gave evidence about it. Then it identifies who they were, says, and gives a brief summary of them. Can't you just scroll down for me on that? And you'll see those footnote references. So let's pick any one just to test it. We'll take the one that's on the top of the screen. So it's Jesse Watton, examined in chief and cross-examined, just the next paragraph. Then cross-examined. He said he and Mr. Lerman played pool while Hamer and Michelle Lewis talked separately, and that Lerman told him he had invited Higgins down because, quote, there's this girl I know looking for a job, giving Watton the impression Lerman had some pre-existing relationship with her. And then as authority for that proposition, it goes to a question from my opponent in that case in cross-examination of the witness. What did you do when you arrived at the Kingston Hotel? Mr. Lerman and I played some pool. I believe Miss Hamer and Miss Lewis were in another part just adjacent to the pool room having a discussion. And if we click on it again, it will then open on the second half of the screen, the transcript itself, so that you can see the page of the transcript from which that proposition was derived, together with highlighting of the relevant text. It's a long transcript, so we'll probably just take a moment.
Take a bit.
Might take a moment to pop on the screen. I'll just drive that for a second.
Sure.
And you can see just how detailed the analysis is here, starting with each of the witnesses who'd given evidence about the event in question, then moving on to a table of what are called consistency. Oh, there's the transcript. Now, the orange transcript is my own personal highlighting during the running of the case. So I had, in the time-honoured way, highlighted and scribbled in the margins. Here, though, AI has managed to discard that, read it for itself, and found a passage about a paragraph above where I had highlighted, which is stands for the proposition inserted into the summary it's given me. Then you can see it's produced, as I asked, a table.
You need to go up. Yeah.
A table of consistencies and inconsistencies, starting with the issue in question and then going through each of the witnesses' evidence in relation to that question before giving some analysis of whether it was consistent or inconsistent. And so, just a trivial, irrelevant matter, but the private conversation duration, there were differing recollections in the evidence, possibly 45 minutes, about 45 minutes, 30 minutes to an hour, approximately 45 minutes. And the AI has said broadly consistent across all 4 witnesses, which is obviously correct. But in more important matters, it will have identified in the transcript each of the matters which bore upon it. Now, this is not AI doing the work of counsel, not at all. if you're counsel, the judicial officer, you lived this trial, you were there when all of this happened. And when you're preparing a closing submission on Christmas Eve under enormous time pressure and very tired at the end of the trial, this is either a job for a junior barrister or a junior lawyer, which has them up doing an all-nighter, or it's produced in 5 minutes by AI and able to be signed off without any risk to professional obligations very quickly, because it's not standing as substitute for my judgment. I was there, and when I read it, I know whether it rings true or not, and I'm able to check those references very quickly. So it's I think, a really powerful example of how the tool can work. Then we think, well, maybe AI, what can AI do about the credibility of witnesses? And of course, AI is not in the courtroom. It doesn't see the whites of the witness's eyes. It doesn't hear the tremor of the voice or those other cues that might be material to an assessment of credit. But it can identify very well patterns, inconsistencies, digging in relation to indefensible propositions, or making sensible concessions on the other hand. And so in this case, let's see what it said, and I'm reading this for the first time with you. On the Kingston Hotel evidence alone, there are real and largely unresolved conflicts between the 4 witnesses on points that are neither trivial nor peripheral, for example, and then it's identified some of them. It's likely got a conclusion, which we can go to. Overall, responsibly stated, this single contained episode, occurring some 3 weeks before the alleged assault, involving only 4 witnesses, well short of the emotional weight of the alleged assault itself, nonetheless exposes credit-relevant features in all 4 accounts. None of the witnesses gives an account which is wholly free from inconsistency, concession, or apparent reconstruction, and on the central factual dispute, the accounts split 2 against 2, meaning the episode cannot on its own establish general unreliability against any one witness over the others. What it can fairly be said to show, going to credit generally, rather than a reliability on this specific occasion, is, and then it goes on to give a conclusion. And now you can accept or reject it. If you lived the trial, it's a trivial matter to read that and come to your own view about its accuracy. Now, can I try, I don't think I've got a way of copying this over. I'm now going to type into a file, we'll then send it away to do some more work. Could you now please prepare a short submission appropriate for insertion in the written closing, include pinpoint references to the transcript, ensure it scrupulously follows my style guide, provide in a Word document, and you'll see I've got about 25 typos, but let's send it off to do that.
It's
We need to stop for sure. Let's move on. We'll come back and show that before we wrap up. And can we do one more back on the PowerPoint presentation, please? The next example, just let's click through. That was in case the technology failed.
we had a backup.
We had a backup. Now, the third example involves one of those tedious tasks that falls typically to junior counsel, identifying the grounds of objection in affidavit material. Again, this is a really useful technique, not because it does the job for you, but because it simplifies it. So in this case, we've given a prompt. I've said, could you please de-identify the deponent from an affidavit from a real matter, not the one we were just talking about, review the contents of the affidavit and prepare a table of potential objections to admissibility for me to consider, having regard to the provisions of the Evidence Act 1995. And we gave the AI a copy of the Evidence Act 1995 so that we could be absolutely confident about what it was working from. So it was given an affidavit, tendered in a proceeding, a link to the Federal Register of Legislation, and what came back was this. It found 31 potential objections in a 6-page affidavit, overkill, but nonetheless, you can see how useful it could be. So paragraph 11, it's identified a passage in an affidavit, an arthroscopy as a procedure for diagnosing and treating joint problems in a lay affidavit. The AI has said correctly that's an expression of opinion from a lay witness with no specialised knowledge. And in the note, not saved by section 78 and so on. That's undoubtedly a correct assessment, but the barrister brings human judgment to bear upon it. Obviously, that's not an objection I'm going to press in a trial. Obviously not going to press it. But nonetheless, a useful saving of time. Next one, paragraph 14. My understanding was that the doctor was regularly used by the RAAF. The AI has identified correctly that that's hearsay and the source of the representation is not identified. And then in the note says, but this may be saved if tendered for state of mind, which clearly it would be on those facts. Paragraph 46, there was a medico-legal assessment and the AI has identified that that's hearsay and opinion, and the business records exception is unavailable because in its note it says the strongest objection prepared for a proceeding, so excluded. That was a point no one thought to take in the actual case. And then finally, there was a piece of hearsay plus expert opinion on causation, and the AI has said, well, you could consider taking an objection to that on the basis that the proper course is to call the person who made the statement. So again, not a substitute for judgment of counsel in any sense, but a huge potential saving of time. I could equally have asked it to review a table of objections provided by an opponent in litigation and give me a draft set of responses. And in the judicial context, one can imagine readily having the objections from one party, the response from the other, and then an evaluation by the AI before the exercise of human judgment is brought to bear on it. And then finally, very quickly,
Let's
you
open
want to go
up.
back? Oh, you want to go back?
I just think we don't have much time
Oh, okay.
to let
Quickly.
them ask
Oh,
questions.
Good. Well, let's go back to, can we go back to the live demonstration and show you the submission it's produced? So it's produced a submission. It said, I've drafted a short submission on this issue and queued it for saving. A technical note on formatting. Oh, that's interesting. I did not have an exact version of your firm's submissions template to use as a formatting basis. Well, that'll be interesting. So we'll see what it's produced just as soon as it becomes available for illustration. There it is. Yeah, it's not done a very good job. Ah, there we go. This is a good example of it failing. So when we tested this earlier today, it produced a beautifully formatted version. No one ever really knows why it works sometimes and not others. But the content's what matters, really. And so it said in this one-page summary, it said both protagonists' credit is seriously impaired. That impairment is illustrated in microcosm by the conflicting accounts given of a single contained episode 3 weeks before the alleged assault. And towards the end, and their accounts diverge on points that go well beyond immaterial matters of detail. And there's then a summary of the matters which bear upon that assessment. And then in 1.5, nothing in this episode resolves the central issue in the proceeding. The phone incident divides 2 witnesses against 2, and the argument that followed cannot be pinned to any single agreed version. What the episode does responsibly establish is that each witness's account of matters collateral to the alleged assault should be approached with caution, and that impaired credit is a feature common to both of the protagonists, not a one-sided phenomenon. That's a pretty cautious submission. In the test we did earlier today, it was much more definitive. Which a curious feature of the technology is you do get different results from identical prompts, even today, even on the same day using the same platform.
Which you know, when you get into the technology, you can see why, right?
You can
Because
see why, yeah.
each time it is generating a new, like it's generating something different. Because that is actually the point of the technology. But we should see if there are questions.
Let's open up to some questions. There were, I think, 2 more use cases we could go through, but it might be worthwhile.
Questions are more important, I think.
We have one right at the front here.
Thanks, everyone. Very thoughtful contributions and a fabulous practice note. So well done, everybody involved. On the topic of disclosure, I'm really interested in contrasting the disclosure that you find pervading the expert witness practice note, for example, and what's in the AI practice note. So, for example, the requirement to disclose your letter of instructions, contrast that with an obligation to disclose the prompts that were used, and you can sort of draw analogues like that. And I'm just wondering whether that pays closer consideration to see if we're consistent. And as well, is the concept that the disclosures needed so that you can scrutinise it appropriately, what the expert has said, does the same rationale apply, that you need the disclosure so that you can understand how the AI came up with what it came up with? Because you don't cross-examine counsel on how did you come up with that submission, what was your thought process. So there seems to be some interesting contrast there about what we're trying to do and why. Why do we want disclosure? What is it that we think we need to scrutinise? And I'm just interested in what the panel's thoughts are on that.
Well, if it's relating to expert witnesses, the expert witness code of conduct continues to apply. So the reasoning process of the expert needs to be disclosed in any event. There's no need for the generative AI practice note to say anything further about that. As to why that needs to be disclosed, well, in the case of experts, it goes to admissibility, and so that there's a fairness as between parties to what that reasoning process is, and if it's not disclosed, objection will be taken undoubtedly.
I mean, if you are, we're not asking the AI to take responsibility for anything, whereas we do ask the expert to take responsibility for something. So, I mean, I don't think it's quite the same question at all. When we have found challenges in the academic space about disclosure, I like students to disclose if they are using AI, and broadly how they have used it, mostly because it's a pedagogical moment, so to speak. It's like I was using it for this purpose. I was using it for proofreading. I was using it for translation. I was using it to do a first draft, and that's the basis for a conversation. Now, I was talking to someone just before this event who said that, in a different context, there had been a request to disclose every single prompt and log every single activity that had been occurring on AI. I can't imagine anything worse than trying to read through all of that as an academic, and I wouldn't ask for that level of disclosure. But I can see how, if you were prepared to go through and looked at every prompt, you could start training them in AI. But again, not my job. It's my job to train them to be a lawyer, not to be the best prompt engineer that you can imagine.
We have a question over here and then over there.
Thank you. It's more a comment. Tony Frost. I'm an ex-tax lawyer, a graduate of Sydney University, and I'm having a second career helping law firms help their young lawyers in the age of AI. And I'm going to give it to you afterwards. I have an excellent guide here, Accelerating a Lawyer's Professional Judgment and Wisdom in the Age of AI. And it's in the second edition. It's on my website, and it's all the law firms need to do this.
Sorry, is this a comment or an ad?
Yes, it sounds like but I want to tell you that seriously, some law firms are getting it, but some more quickly than others.
All right, thank you. We might go over here. I think we're a bit like the ABC. We're not allowed to advertise. Yes.
Good evening. My name's Jacob Carswell-Doherty. I'm a solicitor. I've been using AI for some time. My question was about confidentiality and data residency. I got the point that you made, Dr. Collins, regarding where, for instance, the documents are stored. And we saw in your demonstration that the transcript PDF was on the Lagora platform. My question is, should there be a distinction drawn between confidentiality when it comes to the PDF being stored on the Lagora platform, and then the process that takes place after that, which is tokenization, and then sending that data to the data centers with the large language models on them, like Opus and Fable and all that? Is there a distinction to be drawn there, and should we be treating the two the same, or are there some differences?
It's quite a complicated question. I think unwittingly, we've been exposing client confidential information to risks for years through using products like Dropbox and other services without the protection of contractual guarantees. AI has forced us to focus on this, and there are a series of different questions. Contractual guarantees that the platforms are not being trained on your inputs or its outputs, to me, is foundational. My colleagues not seeing my work and them not seeing mine in a barrister environment is foundational. It's different in law firms. It's one of the reasons why getting these products into barristers' chambers is particularly complicated. There are some requirements around data residency in particular matters of national security, for example. A client might impose an obligation that the data must reside in Australia, on servers in Australia, and not be sent, for example, to the United States or anywhere else, even for processing. At the moment, I think I'm still right to say this in the middle of August 2026, some of the most powerful models do not have Australian-based servers. Others do. And so it's quite a complicated process. That is why we talked about that risk framework that we've developed at our bar for barristers to think through in relation to the particular use case. Can I use that large language model for that for that particular query in circumstances where I know that data is going to be processed in the United States before it's returned? So we look at it in terms of contractual guarantees. Are we exposing data to, in circumstances where it's can credibly be argued that privilege has been waived or a Harman undertaking has been breached? But thinking about in some respects, sending emails has exposed client confidential information to the same risks for 30 years. It's just we're thinking about it much more acutely in the age of AI.
I don't think we have any more questions, but I have a question for each of you. Yep. Are your junior counsel redundant?
I'm really worried about it. I'm deeply worried about it because, as you can see from some of those examples that we've given today, the AI is producing drafts that are approaching the quality of good juniors. And I often say that the job of a silk has always been to look for hallucinations. You're looking for hallucinations in the work of human entities. You're bringing your accumulated experience to identify something which you think needs to be reworked because it's not quite right, or I want some more work done here. Can you go away and do more on that? That's essentially the same exercise of bringing accumulated experience to identify hallucinations and errors in AI product. If AI gets to the point where it's producing drafts that are equivalent to that of very good juniors, that is obviously existential for the junior bar. And it's one of the reasons why we've thought so deeply about how do we embed these products into the life of barristers. There are two ways of fighting back, right? One is to find a way of adding human value to the product which is being produced by the technology. And the second is to look for what the market is doing. And for barristers, if small law firms, mid-sized law firms, government departments and so on are behind, that's our opportunity to offer. We can provide a service to bring you up to the standard of your more sophisticated competitors.
And Kimberly, following on from that, do your students express any concern of an ageing legal practitioner class?
Oh, do they ever? Yeah, I mean, of
that
course
has
they
no
do.
need for, or more
No,
limited need for.
of course our students are concerned. I mean, for years, law students have felt the pressure of, large cohorts of students and limited jobs, and now they have a new competitor in the form of AI. So of course they're expressing concern, and obviously universities like the University of Sydney are doing our best to respond to that, including with much more focused career advice for our students. Reading the speech from last night, the other way that we respond to all of this is the nature of the work changes, the nature of the people that you can reach with justice changes. I genuinely think that there are opportunities for using this technology to reach more people. And that's what, that is also what we've heard from a number of the law firms, was that they weren't suddenly going to go, we're not going to hire people because actually we could do more work. We could have more opportunities. Sorry, I can see you looking at the time and I'm going,
No. Can we all thank Dr. Collins and Professor Weber? If you have time, we have refreshments outside and canapes, so please join us.
Hi, Tony.